You may have seen this video that was posted on YouTube, another West Virginia case that's now winding its way through the criminal justice system. And it has to do with a guy who I believe was from Michigan who was driving through West Virginia on his way to, I think it was Pennsylvania, in an RV, and he broke down while in West Virginia. RV campground. The cops show up and he asks for a warrant. They don't want to give him a warrant, or they don't have a warrant. And you see what happens in the video. Just briefly, this is from the Real News Network, who did a really good video on this. I'd check out their YouTube channel, and they go into the funding of this small town police department. This is Milton, West Virginia Police Department. That's in Cabell County, West Virginia. That's over near Huntington, West Virginia, and this is just one of these tiny departments that's generating a huge amount of revenue with their basically what appears to be for-profit policing.
That's right, 8 immature hemp plants, which is why police in West Virginia decided that Cody was such a threat to the community that they had to break into his home without a warrant. As you can see in the video we are showing now, police insisted that he let them inside. When Cody, fully aware of his constitutional rights, asked to see the warrant, police kept telling him they would get it soon. Let's listen.
So you're gonna break my stuff violently anyway?
You're gonna get a copy of the warrant, yeah. Open the door.
Look, my hands are right here. All I'm doing is recording this. That's it.
Open the door.
I just don't understand why and what's going on. I need to have a lawyer present. For a warrant, why not? This can be done completely peacefully. I just need to see a warrant first. Why are you guys breaking my stuff? I haven't seen a warrant yet. Right now I look like I'm surrounded by a bunch of wolves trying to attack me. Okay, so as soon as I get a warrant, I'll open the door. What's the issue? Well, here we go. This is what they're after. Just so people know the real truth. Whoa, whoa!
Open the door.
I don't understand why you guys are being so violent towards me. That's all.
We're not being violent.
Yes, you are. You just smashed my whole window in.
But this is an interesting video, not because the cops are busting in without a warrant, trying to get a couple hemp plants or marijuana plants. It doesn't even matter at this point. But the question really pops into people's heads, and really pops into my head as well. Do the police need a warrant to search an RV, or to come into an RV such as this in a campground and arrest the guy inside, or search the RV, or both? Do they need a warrant? Well, like many things in the law of Fourth Amendment search and seizure, it's not that simple. You know, generally the Fourth Amendment requires the police to obtain a warrant before a search. But there's a well-established exception, the automobile exception. See, for instance, the Supreme Court case of Carroll versus United States from 1925. Under that exception, quote, if a car is readily mobile and probable cause exists to believe it contains contraband, the Fourth Amendment thus permits the police to search that vehicle without more. So once the police have probable cause, which generally they need to search, but usually in a house, well, always in a house, they need not just probable cause, but also a search warrant. But this is something in between an RV. So once they have probable cause, this is with a car now, the automobile exception, they may search, quote, every part of the vehicle and its contents that may conceal the object of the search. So in 1985, the U.S. Supreme Court looked at the case of, well, what about an RV? You know, it's surprising it took from 1925 with the automobile exception all the way to 1985 before this issue made its way up to the Supreme Court. But that's why the law of search and seizure is highly confusing. So 1985, California versus Carney is the case. The Supreme Court held that an RV or a mobile home, on the facts presented in that case anyways, was more characteristic of an automobile than of a fixed residence. So the court looked at the nature of the location where the vehicle was discovered in that case, but only to ascertain whether that vehicle itself was really a movable vessel or a fixed residence. So the court referenced, quote, a place not regularly used for residential purposes, from which the police would be less likely to infer that the object was residential in nature, and that served as a guidepost to determine whether or not the object encountered was a vehicle or a residence. Confused? All right, so basically to sum up, the holding of California versus Carney was basically that, was the RV on a public road, or was it situated such that it's reasonable to conclude that the RV was not being used as a residence? If it's on a public road, or if it's not reasonable to conclude that it's being used as a residence, then no search warrant is required, only probable cause is required, and the police can come in assuming they have probable cause. So, looking at it more carefully, if you go through that case, what did the court really look at to determine? So it's a gray area, it doesn't really help that much. Is a warrant needed? Well, these are the things really that should be looked at. And I don't know that the answers are really known yet in this particular case. I mean, I know the police know them, but I actually pulled the case file and there was hardly any information in there there was no information as to why the cops were there in the first place, who called them, what the suspected reasonable suspicion of criminal activity was, what probable cause was. None of that's contained in the court file, of course. Kind of par for the course. So not knowing any of these things, these are general things that one would look at. Was the RV in the particular case readily mobile? Now I know in this particular case, apparently it broke down. Is that obvious from the outside? Was it sitting on blocks? I don't know. But was it readily mobile? So if there wasn't an immediate search and seizure, assuming that's why they were there, could the vehicle have been quickly moved beyond the reach of the police? Also, was the vehicle licensed to, quote, operate on public streets and subject to inspection as a motor vehicle? And we have inspections in West Virginia. I know it was an out-of-state vehicle, so it may or may not have inspections where it was from. Secondly, was the vehicle so situated that an objective observer would conclude that it was being used as a residence but not as a vehicle? Well, it wasn't on a public road. It appears to have been in a campground. How long had it been in that campground? Again, was it sitting on blocks? Was there all sorts of camping materials brought outside? Did it have like a little front porch set up? Were there shades on the windows or like a sun blocker along the front that sometimes you see? I don't know. These are all facts general facts that could, bring it out of the gray area one way or the other. Third, really the last thing that one must recognize is that whether or not there was a search warrant, whether or not a search warrant was required, or rather, even if a search warrant was not required because it was objectively more like a vehicle than a residence, was the search that actually occurred still reasonable? Because even under the automobile exception, the search still has to be reasonable under the circumstances. So was the search that actually occurred otherwise reasonable? Was it something that would have been approved by a neutral judge had they applied for a search warrant? So that doesn't really help much, but that is the answer. There's no black and white holding that, yes, in an RV, the cops still have to have a search warrant to search it. And it makes sense that the Supreme Court wouldn't have done that, because then, actual criminals could just drive around an RV and deal drugs or whatever they're doing out of an RV, and they wouldn't be subject to search. Which I'm not saying a search warrant should be required, but that's why obviously the court never held that. So that's the gray area of that corner of Fourth Amendment search and seizure law. I'll try to follow what's happening in this case in Cabell County, and the family did reach out to me. That's why I pulled the documents. So I'm trying to look into it. He has a public defender. He's still sitting in jail. And last I heard, he hadn't gotten any calls back. The family hadn't gotten any calls back, just sort of rotting in jail. It's unfortunate. I'll keep following this and maybe do an update video when I find out more details, such as why the cops were there and all that. So thanks for watching.